law dictionary definition is actually slightly different than what we're going to see in the case law, because in this definition, it talks about intentional destruction, mutilation, alteration, or concealment of evidence. But in the case law, we're going to see that spoliation can also be due to negligent conduct. It doesn't have to only be an intent to deprive another party of the use of that information. And if proved, spoliation may be used to establish that the evidence was unfavorable to the party responsible. And we're going to talk about that in connection with adverse inferences, where that assumption is correct. I think it falls down with when we're talking about negligent conduct. I think it's harder to assume that the evidence was unfavorable. So next slide, when we talk about elements of spoliation or of a sanctions claim, first, the party seeking the sanctions based on either a failure to preserve or the destruction or loss of relevant evidence has to demonstrate essentially three things. First, that the party who had control over that evidence, and it's not just possession, it's possession, custody, or control, had an obligation to preserve it at the time it was destroyed. Second, that that information was destroyed with a culpable state of mind, and we're going to see what that state of mind needs to be is different in different jurisdictions. And three, that the destroyed evidence was relevant to the party's claim or defense, such that a reasonable trier of fact could find that it would support that claim or defense. So in essence, the absence of the evidence caused prejudice to the party that was claiming the spoliation. And Justice Crothers, I'm going to turn it over to you to dig into those elements a little more deeply.